Recalling page 12, case number A831379, Nikolai Shaparov versus defendinglifestyles.com.
Morning again, Your Honor. Will Kemp.
Morning, Your Honor. Good morning.
Good morning, Your Honor. Gina Mushmeche on behalf of the Real Water defendants.
Morning, Your Honor. Jim Cavanaugh, ETT1, DBA Terrible Herbst.
Good morning.
Good morning, Your Honor. On Zoom, Colt Dodrill and Karen Basher for Nevada Beverage.
Morning. All right. Well, had I known how long that other one would have gone, I would have called you all before that one, but plaintiff's motion to consolidate Shaparov and Herbst on order shortening time. Reviewed that, reviewed the Real Water folks opposition, Nevada Beverage folks opposition, plaintiff's reply, and the Terrible Herbst joinder in the opposition or oppositions. I'm probably inclined to grant this. You know, as pointed out, obviously I separated one out before, and at this stage, though, there have been that actual trial already went forward. There's been, I don't know how many now, but 2 or 3 after that. And as pointed out, multiple depots and trial testimonies, and I don't think there are a whole lot of surprises anymore. And we also now apparently have substantial, if not complete, production of plaintiffs' medicals, I think is mentioned in the reply. So welcome arguments begin with plaintiff.
And Your Honor, I'll be brief. You know, the plaintiffs have basically the same interest as the court system. Rather than try the case 7, I've tried this case 5 times now, and this will be the 6th.
See, I like I said, I don't know how many.
Right. So rather than do 7, I'd like to combine this one, try to get out of 6, which is kind of staggering when you really think about it. But in any event, liability's done for Terrible Herbst and Nevada Beverage. We've set forth the 9 depositions when they were taken. They were taken about a year ago. They filed expert reports 4 different times. They have taken my food safety expert, Dr. Hutt, who you may remember from the last trial. They've taken her deposition at least twice. So liability is pretty much a done deal. Well, it is a done deal. So all we're talking about is doing damages on one case, which is a death case. So using the only other death case that's been tried as a touchstone, that's the Gallagher case. We did 3 depositions in that case of the heirs that lasted 45 minutes each. I would expect there's going to be more depositions in this case, honestly, on the damages. I think there's only 2 heirs. There's the 2 daughters, but I would think we're going to have at least 2 product ID depositions, and they may want to run down to UCLA. I don't think there's a need for that, but they may want to. So, you know, the real issue is, can we do 5 depositions in this time frame? I would say pretty certainly we can. As I pointed out in the motion, I have been whipping up the paralegals to do all the medical records gathering, and we've been extremely successful, not so much because of our efforts, but because UCLA is so organized. So we actually have 14,049 pages of medical records now for the Herbst case. That exceeds all the medical records for all the other cases combined. But the primary medical record, I think, is the MRI imaging of the liver. We have produced that. We have not just produced the MRI report. We have
The original, right?
Yeah, I've looked at it myself, Ron, and watched the imaging myself. So that's available to their experts. And if they need a slight extension time, I don't think they're going to need anything for liability, but if they wanted 2-3 weeks for their extension time for their causation expert, who I've probably deposed already at least 3 times, that's fine with me. But you know, we've been pretty accommodating on that. So for those reasons, Your Honor, we agree with you that this should be consolidated and neither the court system nor I should have to try the case 7 times, 6 times is enough.
Thank you.
Good morning, Your Honor. Colt Dodrill, counsel for Nevada Beverage. We obviously disagree. Plaintiffs moved to consolidate under Rule 42. We opposed it under NRCP 1, which reminds us that we have to apply the rules of civil procedure to get a just result. And we don't think there's justice here. This case is entirely different. And I know Your Honor did not try the Gallagher case, but in the Gallagher case, there was a death case. It did not involve a significant statute of limitations defense. This case sticks out like a sore thumb because Mr. Herbst passed away 4 years after real water product was no longer available and 2 years after the statute of limitations ran. That opens, that separates this case from all the others because we're going to have to do extensive discovery specific to the statute of limitations, including getting all his emails, his text messages with his family members going back to 2021 when the recall was announced, when the product was pulled out. The medical records, we just got some from plaintiff this weekend. The case is new. We just barely answered the case last week. Some of the medical records we saw do say that he had 3 to 4 glasses of wine every night. And I'm sure those facts aren't present on all the other folks that are in the combined Shaparov case. Also, he did have cirrhosis, according to his medical records, secondary to alcohol abuse. And I'm sure most of the plaintiffs in the Shaparov case do not have that. And in fact, I'm not sure of it because I haven't received or reviewed those medical records. This case raises a very unique situation where Mr. Herbst complained of symptoms that his family associates to real water in 2016, yet he passed away in February of 2025, which raises a unique question as to why his illness continued to accelerate and why he died 8 years after the symptoms. What caused him to die 8 years later when all the other plaintiffs recovered on the good hospital water? So this case sticks out more so than the Lila Cavay case that Your Honor mentioned earlier. To try these cases together would be unfair on the facts, and it's unfair on the discovery. If you look at their reply, they list all the depositions that they took. We haven't taken any depositions, and it's not just the 2 plaintiffs that counsel mentioned earlier. It's anyone that he would have had contact with to establish when he knew or should have known that real water was associated with this outbreak of acute non-viral hepatitis. That's going to take a lot of time. Again, discovery into his emails, discovery into his communications. What is he getting? This is not just a Joe Schmo person. This is a Boulder City quasi-celebrity that had a popular wine bar. And so he's in the food and beverage industry. And one would suspect that he gets food and beverage related news releases, including information from the FDA that says real water's been associated with this and the product has been recalled. All that happened in 2021, which begs the question why somebody in the know wouldn't know about that till 2024, at least as alleged in their complaint. So that's going to add to what plaintiff's counsel refers to as liability discovery. We think there's additional medical records. We want his baseline. Plaintiff's counsel are very good at saying, here's the medical records when he got sick. We need the medical records before. We need the before and after to see when he had a pre-existing condition, when he first developed symptoms consistent with liver injury, including cirrhosis. Plaintiffs took depositions of real water folks, Nevada Beverage folks, and Terrible Herbst folks, but we haven't taken depositions of their folks. And some of these people that aren't plaintiffs, sometimes they take a long time to track down. And for us to get experts next month on a case I just answered last month is a bridge too far. We also need to confirm purchases. He sued Terrible Herbst. It takes time to track this down. I haven't seen records that would show his purchases. Most people don't keep receipts. So that has to be investigated and vetted. We can't just take plaintiff's word for it that he purchased the product. It's also unfair on procedure. That's too soon for trial. Your Honor, this is one of two cases that I got after the statute of limitations ran. The other case doesn't have trial till 2026. But all of a sudden on this case, we've got to push and rush to get ready for trial in October. And plaintiff presupposes that we're going to use the same experts. We think that's gamesmanship. They've deposed our experts. They've also moved to strike those experts. Some of those experts were jointly retained by other defendants, and plaintiffs had been successful in getting some of those experts excluded. And we think that part of the impetus for filing this motion is to hamstring us and force us to use experts that are running risk of having their testimony limited or stricken. We don't think that's fair. And we would ask that this court move or just allow the Milo Herbst case to remain in its jurisdiction in front of the department where it is now and go through discovery and trial in its ordinary course. Thank you.
Thank you. Before we turn it over to any of the co-opposing or joining parties. So one question, because I'll kind of ask the opposite question or the same question, I'm not sure, on play side. So a lot of your argument was related to hey, we don't have enough time. This is a new case, or we're new to the case, or mostly, yeah, admittedly, you know, the Herbst case is a new case. So you expressed a lot of concerns and arguments vis-a-vis a lack of time. So, and this is a question. I'm not saying this is what I would or would not do, but couldn't a lot of your concerns potentially at least be addressed by a trial continuance?
Your Honor, if the trial were continued to 2026, that would resolve some of the discovery related concerns, but it would not address the prejudice related concerns. There's still this overflow of evidence, what the courts call bolstering, where having a death case would bolster the Shaparov's claims, and having injured infants in the trial would bolster the Herbst claims, and everybody spills over all of their evidence into this big pot, and that's what we've seen in the other trials. And the court need only look at the punitive damages awards in the other trials that increased dramatically once plaintiffs' claims were consolidated. The Gallagher case was one complaint. The Hunwartzen case was one complaint, but Wren, Brown, and the Bonner, Van Buren, Bordenave, which just was the most recent to have completed, those had punitive damages of 20 to 30 times more. They went from 100 million to 5 billion with a B. And that prejudice is not going to be absolved if the trial is continued a year or more. That's just going to continue to exist. And that's not fair to us. That's not fair to any of the defendants. And that's why this case, this death case with cirrhosis, needs to be carved out and kept on its own track.
Thank you very much. Any other opponents?
Your Honor, Gina Mushmeche on behalf of the Real Water defendants. And I think I'm not going to repeat anything counsel for Nevada Beverage articulated for you, but I think prejudice is the key here. I understand this court has discretion, but it's got to be reasonable discretion, and the risk of prejudice must be viewed with greater scrutiny. Looking at all of the factors with that greater scrutiny, Herbst is very unique. As counsel explained, exposure, consumption, and proof of medical conditions will be individual to Herbst as opposed to the 2020 outbreak plaintiffs like the Shaparov plaintiffs. And again, it's a wrongful death versus acute injuries, which will end up being a trial within a trial. And I think courts regularly in toxic tort and products case avoid consolidating death and acute injury cases all of the time. The juries may believe that the claims are interdependent on each other, risks the jury will inflate the value of the acute injuries based upon inclusion of a death claim, essentially causes confusion and prejudice. And the best example in asbestos cases, the courts regularly sever mesothelioma death cases from non-fatal pleural changes or asbestotic cases. They're all lung disease cases from exposure at a work site. And if we use the term transaction and occurrence broadly, as the plaintiffs do here, the courts in those cases say no, because recognizing the prejudice of including a death case with non-fatal claims. Same thing for a Legionella case I cited for you. It was a water system death severed from non-fatal exposure because illness, history, length of exposure would confuse a jury. So based on all of this, I think care must be taken that consolidation does not result in unavoidable prejudice or unfair advantage. Conservation of judicial resource is a goal. However, when those savings are slight and the risk of prejudice to a party is great, then the court should not consolidate a wrongful death case with acute liver injury cases. And for those reasons, we believe consolidation is not appropriate here. Thank you, Your Honor.
Thank you.
Good morning again, Your Honor. Jim Cavanaugh for Terrible Herbst, ETT1 DBA Terrible Herbst. Your Honor's right. There's been I think your words were multiple trials. There've been 5. And the one common factor in all these cases, including Herbst and the next trial before Your Honor, the Shaparov, is the excellent law firm and plaintiff's counsel to my right, Will Kemp, and his entire firm.
And Mr. Pepperman.
Well, no, I'm not at all excluding him, and I would have said his name too. But that's a fact. That's the commonality here. There've been 5 trials. Only the first trial contained anybody but the real water defendant entities. All right. 4 trials, after that, only real water entities. So there hasn't been this multiple instances of these defendants who are opposing this motion, either Nevada Beverage, who is Terrible Herbst's distributor of the real water. We've not participated in any of that testimony, nor any of the cross exams.
Well, since
And if I may, we've only been involved in 2 cases prior to this with Mr. Kemp's firm. One was settled based on some discovery issues in Judge Kishner's courtroom, and a settlement that included the entirety of all the claims, including the faults of those discovery issues. And a second case that was Hunwart's. The second case was the Taquante Henry Brown case. Again, it was settled prior to trial. There was no opportunity to go further, and that was none of those verdicts involved Terrible Herbst. And that's a big difference here. Besides the commonality of the good plaintiff's firm in all these 5 trials and the desire not to want to do a 7th one after the one that's before Your Honor, is there are different defendants and there are different plaintiffs that plaintiffs and Shaparov seek to consolidate into their matter. Different defendants, different plaintiffs. And the fact there have been other discovery and other experts doesn't take anything away from the fact that they just filed this lawsuit February 28th and then amended the Shaparov time schedule to where it has its current discovery deadlines and 1 month from now, expert disclosure deadline after they had filed the February 28th lawsuit against our clients. So we have different, and we have lots of different facts. I won't bore you again with going through those, but there are substantial differences. There's no, there's just no question. The facts and alleged damages are different in a wrongful death case and the cases before Your Honor and the Shaparov matters. I won't go through those again. There's undue prejudice. I mean, there's prejudice when we walk out the door in the morning, but there's undue prejudice to force these new defendants, these different plaintiffs and defendants, discovery. Your Honor offered an option. Certainly that's way better than pushing us into a trial that's currently set in October with all those deadlines as an alternative. But the prejudice is clear, as both counsel for the defendants have already pointed out. The bolstering, the being in a trial with injured infants, nobody wants to be there. And we have an owner of a wine bar with a substantially different background and injury scenario here. It really deserves, and the defendants deserve, a fair opportunity to conduct discovery, retain experts, and participate as they should in defense of our clients. Thank you, Your Honor.
Thank you.
With regards to Mr. Cavanaugh's comment, the reason that the retailer entities haven't participated in the trial is because they've settled.
Yeah, I think that's the question I was gonna ask, but he raised it before.
And Nevada Beverage Council, Mr. Cavanaugh, they're smart attorneys. I don't think they like standing up next to real water in a case like this. And that's, I think that's what's motivated the settlements. But that's a reason for consolidation. If you take a look at the case law, factor 3 is whether settlement of the claims or judicial economy would be facilitated. So that favors consolidating these. That hasn't been argued, but that favors consolidating. But getting to their bolstering argument, they have a theoretical bolstering argument that you can never try a death case with an injury case because that will allegedly inflate the valuations. We have tried a death case with an injury case. We tried the Gallagher case. That Gallagher case, those were the lowest compensatory verdicts of all 5 cases. The punitive verdict was $200 million. The 3 non-death case verdicts, the last 3 were $3 billion, $5 billion, and $3 billion. So there is no factual support for this theoretical prejudice of bolstering because the actual results belie that. Their argument that we can't try retail cases with 5-gallon cases. We've done that 5 times. I set forth the plaintiffs, the specific plaintiffs in the case you had, the Wren case. Mr. Tagano was a retail case, and the babies were largely, so one of the babies was 2 of the babies were high-grade cases, but 3 of the other babies were 5-gallon cases. So that is not an issue because, as the court may remember, the real water is all made the same way by the same guy using the same technique, and then they put some in the retail bottle and some in the 5-gallon bottle. So the type of container is really not relevant. Mr. Nevada Beverage brings up this statute of limitations argument. First of all, I don't know how a defendant is going to make a credible statute of limitations argument under that Atkins case, because the court's familiar with the Atkins case that just came down. It's an issue of fact that looks at what the common members of the public would know or not. So we know what the common members of the public would know because we've done these questionnaires with the jury. And to my amazement, nobody in the jury, even after a $3 billion verdict and a $5 billion verdict, in the last case, no one in the jury heard about real water or the litigation. So, and I attribute that, it's kind of funny. We have more social media, supposedly more access to news stories, but no one reads the paper anymore. Nobody reads the paper anymore. And that's where I've talked to attorneys around town in the last 3 or 4 months. They've never even heard about the real water litigation, which they're litigators, which is amazing. But if they think they can win an Atkins motion, fine, bring the Atkins motion. His point as to the discovery, we allege in the complaint how Mr. Herbst found out about this. He read the paper after the Wren trial. he read about the Wren verdict and he talked to his daughter about that. So when they depose her, they'll get that. When the other daughter, I don't think knows too much about it. But you know, they want to get all these emails. They're gonna find out Mr. Herbst was not really an email person. He was in his 70s. He's really not of that generation. But you know, we'll give them what they request, Your Honor. That's not a reason to delay the case. So for those reasons, I think your initial ruling was correct. I would add one more caveat. I would say, let's set this down. Let's grant the motion, set it down on a status check for 30 days. Once they get into the case, if they have more specifics, they think maybe there should be a trial continuance from the October stack to the January stack. We can listen to that, Your Honor. I mean, you know, that's not a hill for us to die for. And if they want to come in and if they take a real good look at what we've already produced, and if they tell us what they want to produce, we can't get it for them timely, you know, I'll stipulate to an OST to move it from the October to the January stack. You know, and I would stipulate anyway, but for the record, I'll say I'll stipulate to it. But so I think we should just grant the motion, put it down for 30 days status check and go from there.
Thank you. So that last point address, you know, so I don't have to ask you the question I asked in terms of discovery. I'm going to grant the motion to consolidate for all the reasons articulated in the motion and the reply, applying the factors, you know, as pointed out, you know, this is not the first, second, third, fourth, or fifth trial apparently. So that weighs into consideration as well and goes along with all the discovery that's already been done to address, you know, potential discovery issues in this particular case. You know, that can be addressed through, you know, further efforts, further you know, individual plaintiff discovery potential, and to be candid up front, there's a real potential we'd move your trial. So that addresses all of those, you know, the discovery related potential prejudices. As noted, the statute of limitations is affirmative defense. You know, that will be incumbent on, you know, the defendants to raise that and file whatever motions they deem appropriate if they want to. But it's not a reason not to consolidate the case. You know, of the trials, they've all been consolidated to some degree. I don't see the harm or prejudice here. All candor, I think it may, you know, there's and good stuff. So the motion granted, and let's see. I just want to see what if anything is your next date already. Yeah, so at least in front of me, you're not back until August. So let's, it's a business court case. I'll be proactive. Let's bring you back here in 4 weeks or so on discovery status, trial status. When would that be?
That'll be June 9th at 9 AM.
See you in a month.
Thank you, Erna.
Thank you.
Thank you.